hearing of the Subcommittee on Competition Policy, Antitrust, and Consumer Rights on the oversight of federal enforcement of the antitrust laws. Senator Lee and I have long presided over this subcommittee together, and once again, antitrust is an area of bipartisan cooperation. I know we've had hearings with the former administration, the Trump administration's head of the FTC, and your former head of the DOJ Antitrust in Macon Delrahim, and I hope that our bipartisan goodwill will continue. I want to thank everyone here today. I know there's many interested parties, and we also thank the ranking member of the Judiciary Committee. I believe the chair will also be with us today, but Senator Grassley is here. It's painfully obvious to me and to many other people that we have competition issues throughout our economy. And what sometimes isn't clear is how it impacts all Americans every single day. It is competition that is the great part of capitalism. It drives down prices for consumers. It pushes manufacturers to innovate and improve their products and forces companies to pay fair wages to compete for workers. Competition provides opportunities for entrepreneurs to start and grow new businesses, fueling economic growth. But if you look at our markets today, there are big cracks in the free market foundation. Now, there's still very many areas of our economy where there is competition. But in a number of areas, we're seeing bigger businesses and fewer competitors and more dominant companies using their market power to suppress their rivals and line their own pockets. In over 75% of our industries, ranging from agriculture to pharmaceuticals to tech, a smaller number of large companies now control more of the business than they did 20 years ago. This is raising prices for Americans. The lack of competition is estimated to cost median American household $5,000 per year. This is not the first time our nation has faced a competition problem. Our nation's fight for competitive markets goes back to the American colonists who fled England seeking religious freedom, political freedom, and yes, economic freedom from overbearing monopolies. It was these colonists who dumped all that tea into the Boston Harbor on December 16th, 1773. They did this not only to send a message that they wouldn't support taxation without representation, but also to show that they wouldn't be forced to buy tea from a bloated monopoly like the East India Company, which could drive colonial tea merchants out of business. Because, to quote Adam Smith, the so-called godfather of our capitalist system, the invisible hand of competitive entrepreneurship is the key to a strong economy. But only, in his words, if we have a government that takes on the, quote, overgrown standing army of monopolists. While I'm quoting people well from the past, Senator Lee, a student of history himself, consider this one from Senator John Sherman, a Republican from Ohio, Sherman of the Sherman Act, who famously said, if we will not endure a king as a political power, we should not endure a king over the production, transportation, and sale of any of the necessaries of life. So that's why this has always been a bipartisan issue. American prosperity stands on a foundation of open markets and fair competition. We know that government can protect the economy, consumers, and entrepreneurs by making sure that we have a check on what Adam Smith called the standing army, the overgrown army of monopolies. Updating our antitrust laws is a bipartisan goal that we have talked about for years. We've held a number of hearings on how antitrust issues affect industry across our economy, both in the Senate and the House. We have one bill, Senator Lee's bill, and I'm the lead Democrat on the bill about making sure our state AGs are able to keep their venue that is currently sitting over in the House. We have another bill Senator Grassley and I have passed through the Senate as part of another bill to finally update the merger fee, something he's wanted to do for a while, which would help our agencies. Senator Cotton and I have a bill. We have numerous bills on competition, and especially in this area of tech, for which we have not passed a competition bill since the advent of the industry. So while today we're going to be focusing on oversight of our antitrust agencies, I think it is very important for both parties to also turn the mirror back on ourselves in Congress and do more than just talk. It is time to legislate and get these bills done. We have many, many opportunities to create some common sense rules of the road to make sure that entrepreneurs and small businesses can compete on a level playing field, and also to give those that appear before us today more tools to do their job in a modern economy. Of course, our country's competition problems go beyond our digital markets. Just ask anyone who has ever had to choose between filling a prescription and filling their refrigerator. That's why a number of us have worked together on prescription drug market issues, including Senator Blumenthal and Cornyn. And a number of us on this subcommittee are looking at broad changes to our antitrust laws as well. It's clear that there are places where we need new laws, but in many cases what we need, as I noted, is funding to make sure the antitrust agencies can enforce laws already on the books. I am thinking of the case that was actually the cases started during the Trump administration with the FTC taking on Facebook under your predecessor, Ms. Khan, and under your predecessor, Mr. Cantor, to take on Google. And I think about that because those are huge cases against some of the biggest companies the world has ever known, and you can't take them on with duct tapes and Band-Aids. You actually have to have the resources to have the lawyers to do it while you are looking at all these other rampant number of mergers and other things that are going on across our country. We want to make sure that our existing laws are being enforced, that anti-competitive mergers are stopped, that competitors aren't agreeing on prices, and that companies with market powers aren't abusing it. I think there is basically bipartisan support for that, even though there may be differences on the means. That is why oversight of the antitrust agencies is a key function of this committee. Millions of consumers depend on your efforts to ensure that the economy is sufficiently vibrant to keep prices low, quality high, and innovation strong. Before I turn it over to Ranking Member Lee, my office received a statement from FTC Commissioners Wilson and Phillips, which I would also like to add to the record unless anyone objects. All right? It is, both statements are admitted into the record. Thank you.
Thank you, Madam Chair. This subcommittee regularly holds oversight hearings on a whole host of topics, many of which are important to the American public. But none of them are more important that we do here than those that deal with the oversight over our antitrust enforcement agencies. And today is no exception to that. Antitrust law and policy have had an outsized importance in our economy and in our country over the last few years, with voices on both sides of the aisle and across the political spectrum generally calling for change. Well, almost halfway into the Biden administration, there's no doubt that we've had change. And the question is, how has that change impacted the American people? And what have been its consequences? There certainly have been some bright spots. For example, the Justice Department and the Federal Trade Commission have ably continued the Trump administration's respective monopolization suits against Google and Facebook. And both agencies have pursued aggressive enforcement in key industries such as tech, healthcare, air travel, and agriculture. Perhaps most importantly, our antitrust enforcers appear to have recovered an understanding that under enforcement of the antitrust laws can at times be just as harmful to the American consumer as over enforcement. But there's also some cause for concern. At the Antitrust Division, we've seen a broad rhetorical assault on the consumer welfare standard, the bedrock of modern antitrust analysis, which has ensured that consumers and not political interests come first. We've also seen a strict aversion to settlement agreements, something that prevents putting the division in a position of a regulator, but which may also be leading to fewer enforcement actions overall, and more fix-it-first remedies, remedies in which the government has no input at all. I have more concerns about the FTC. I've received a flood of complaints over the last 2 years that our antitrust enforcement regime is becoming increasingly politicized, that new enforcement policies reflect not a concern for consumers or competition itself, but merely a desire to delay and impose taxes upon as many mergers as possible. Removing from the FTC's mission statement a commitment not to unduly burden legitimate business activity, ending early termination of the HSR waiting period for harmless transactions, sending toothless warning letters to parties in mergers the FTC doesn't block or in some cases even investigate, imposing prior approval requirements without regard to the actual risk of harm at issue. Actions like these do nothing to protect consumers, and they do nothing to protect competition. They simply impose costs that can crush many businesses already struggling to compete and survive in the Biden economy. That isn't tougher enforcement. No, that's just pettiness. And sadly, the data confirms it, as Commissioners Phillips and Wilson point out in their testimony to the subcommittee. Quote, in fiscal year 2020, the FTC brought 28 merger enforcement actions. In fiscal year 2021, that number dropped by nearly half. And a majority of those 15 challenges were filed before the Biden administration came into office. Fiscal year 2022 witnessed only a slight uptick, bringing 19 challenges with just 2 weeks of the fiscal year remaining. This total falls short of the 2020 total and does not exceed the number of enforcement actions brought in any prior fiscal year, going back to 2015. These data are even more striking when considering that the number of merger filings in 2021 and in 2022 was significantly higher than in any of those prior years, close quote. Now, policy statements, speeches, listening sessions, interviews in glossy magazines, scripted and choreographed public commission meetings where commissioners don't actually talk to each other, all of these are good at generating headlines. But none of them do anything to help American consumers and citizens. Getting good press isn't enough. Talk is cheap. Actions matter. And there, sadly, we've seen a marked decline in what the FTC is actually supposed to be doing, enforcement. Moreover, what little we have seen from the agency has frequently been legally questionable and ill-considered. And no, having one empty commissioner seat is not an excuse when the commission has historically operated on a bipartisan basis. This is what's so concerning to me, that at a time when there's broad bipartisan support for stronger antitrust enforcement, our antitrust enforcement agency, that is the one that by its own statutory design is intended to operate on a bipartisan basis, would defiantly eschew that collegiality and cooperation and sacrifice actual enforcement for flashy headlines. We see this in the use of far-left activists to staff the FTC's Office of Policy Planning, as unpaid consultants, despite rampant conflicts of interest. And we even saw it in the agency's testimony for this hearing, which broke with long-standing norms when that testimony was voted out on a partisan basis. Sadly, it appears this assessment is also shared inside the FTC itself. Recent reporting revealed that staff morale and faith in FTC leadership has sunk to historic lows. The Bureau of Competition, previously ranked the third best place to work among its peers within the federal government, in a very, very long list. The third place was quite a good place to be. It's now ranked 401st. Whatever your view of antitrust policy, Everyone should agree that we need functioning antitrust enforcement agencies, and I increasingly worry that the FTC no longer meets that basic threshold standard. And so this hearing could not come at a better time, at a more opportune time, as there is much to discuss. And I look forward to hearing from Assistant Attorney General Cantor and also from Chairwoman Khan and the conversation that follows. Thank you, Madam Chair.
Thank you very much. Senator Lee, the chairman has arrived. Chairman Durbin, you please share a few words with us.
Thank you, Senator Klobuchar, and Ranking Member Lee for holding this oversight hearing on federal enforcement of antitrust. I'd also like to welcome Assistant Attorney General Cantor and Chair Khan. Thank you for being here. The Judiciary Committee has been busy in the antitrust space in this Congress. At last count, we have held 11 hearings, including today, on competition policy and reported 9 competition bills, with another on this week's markup agenda. Senator Klobuchar has been our leader on this issue. In our first antitrust subcommittee hearing, I commented that she knows antitrust and, in fact, wrote a book about it. I hope that over the course of this Congress, we've held enough hearing to give her grounds for a new sequel. Our hearings and bills have covered a wide variety of topics, from credit card fees and prescription drug markets to food supply chains and big tech. Antitrust law doesn't always make great sound bites, but the laws are essential. Competition drives innovation and the economy. It forces business to improve products and services while lowering costs for consumers. Although competition issues are complex, we cannot afford to ignore them. The cost is literally too high. For example, last year, American businesses paid an extraordinary $77 billion in fees for credit card transactions under the Visa MasterCard duopoly. Those fees are passed along to consumers in the form of higher prices and contribute directly to inflation. A few months ago, Visa's CEO confessed when he said, "Inflation has been positive for us." If there ever was an industry where more competition is needed, it's the credit card network industry. That's why Senator Marshall and I recently introduced the Bipartisan Credit Card Competition Act. This bill would direct the Federal Reserve to ensure that giant credit card issuing banks offer a choice of at least 2 networks on their credit cards, one of which must be other than Visa or MasterCard. But it's not just the credit market that's a problem. In the pharmaceutical market, drug prices are skyrocketing. A major health insurer based in Chicago told me that the #1 driver of higher premiums on healthcare is the cost of prescription drugs. In digital markets, gatekeeper companies are consolidating control. In the agricultural industry, consolidation is creating enormous challenges for producers and consumers. The list goes on and on and on. While we're working to address these competition concerns, more needs to be done. I'm glad Senators Klobuchar and Lee are holding this hearing. I look forward to hearing more about the FTC and the Department of Justice efforts to ensure markets are competitive and working for consumers. Thank you, Madam Chair.
Thank you very much, Chairman Durbin. And Senator Grassley is going to say a few words, our ranking member. Thank you, Senator Grassley.
Quite some time, I've been concerned about consolidation and anti-competitive behavior in several areas of the U.S. economy, from agriculture to healthcare to technology. While big isn't necessarily bad, big can facilitate a company's ability to unfairly exercise or exert its market power. Further, large size and industry concentration can intensify a company's predatory actions and intensify the company's adverse impact on market participants and consumers. Vigilant and very vigorous enforcement of our antitrust laws is important to enforce, to ensure that markets are free and fair and participants don't engage in abusive behavior that harms consumers. The Justice Department and the Federal Trade Commission have played a crucial role in making sure that everyone is playing by the rules. That's why I'm a lead co-sponsor of a bill that we entitled Merger Filing Fee Modernization Act to ensure that the antitrust agencies have adequate resources to do their job. There are a lot of dedicated staff at both agencies that can do good work for the country, but I share concerns just expressed by Senator Lee about the Federal Trade Commission's low morale, management, and partisanship problems, as well as both agencies' push for radical antitrust policies. These problems hamper the agency's ability to enforce antitrust laws. Regular congressional oversight, like we're doing today and this subcommittee has done on a regular basis, will help keep the Justice Department and Federal Trade Commission accountable.
Thank you very much, Senator Grassley. Now I'd like to introduce our witnesses. Jonathan Cantor is the Assistant Attorney General for the Antitrust Division. Prior to joining the DOJ, he worked in private practice for 20 years. 9 former heads of the Antitrust Division, representing every presidential administration going back to Gerald Ford, wrote a letter to the Senate to voice their strong support for Cantor's nomination. He earned his BA from SUNY Albany and his JD from Washington University School of Law. Lena Khan is the chair of the Federal Trade Commission. Previously, she was a law professor who taught antitrust law. She also served as counsel to the U.S. House Judiciary Committee's Antitrust Subcommittee, where she helped lead the committee's groundbreaking bipartisan investigation, led in part by Representatives Cicilline and Buck, into digital markets. Khan earned her BA from Williams College and her JD from Yale Law School. If the witnesses could now please stand and raise your right hands, including, okay, thank you. Do you swear that the testimony you will give before the subcommittee shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can now be seated, and I will recognize the witnesses. First up, Mr. Cantor, please proceed.
Thank you, Senator. Chairwoman Klobuchar, Ranking Member Lee, Chairman Durbin, Ranking Member Grassley, and distinguished members of the committee. Thank you for the opportunity to appear before you today and for your support of the Antitrust Division's work to protect competition. These efforts are vital to our economy and to our democracy. I'm truly inspired every day by how the division staff is meeting the historic challenge of protecting freedom in our economy. We're currently litigating 7 civil antitrust lawsuits, the most in decades, and we will litigate more merger trials this year than any prior year. We are also actively litigating 19 criminal cases, and we ended fiscal year 2021 with 146 pending grand jury investigations, the most in 30 years. In other words, we are doing the work to serve the American people. And I'd like to highlight some examples of the scope of our work and also highlight that the work is being undertaken by some of the most hardworking, professional, and dedicated people I've ever had the privilege and honor to work with, the Antitrust Division. We're working broadly to defend competition in labor markets, including by criminally prosecuting employer collusion in labor markets and prosecuting attempts to cheat workers of competitive wages and benefits. In addition, consistent with the President's executive order on competition, we have launched new and expanded partnerships across the government, including with the USDA, NLRB, and the Department of Labor. For example, working alongside our partners at the USDA, the division deployed the Packers and Stockyards Act. For the first time in recent memory, perhaps the first competition Packers and Stockyards case ever at the Antitrust Division, and the exploitative and unfair tournament system that harms so many farmers and growers. And this will hopefully help to start shifting bargaining power back, in particular small farmers. Second, we are enforcing against illegal mergers with new vigor, suing to protect competition rather than agreeing to inadequate settlements. Among other cases, we are challenging mergers that would harm our supply chains. For example, last month, after a thorough investigation by the division, we successfully blocked a proposed acquisition by a Chinese state-owned supplier attempting to consolidate over 90% of refrigerated shipping containers. And as I explained in my written testimony, the division strongly supports passage of the Foreign Merger Subsidies Disclosure Act, which will bring much-needed transparency to the pre-merger notification process. This comes on the heels of another successful challenge relating to the shipping industry, where we blocked a merger involving shipping equipment suppliers. The division is also working to strengthen our merger guidelines along with the FTC because we believe Congress knows what it meant and meant what it said when it passed our merger laws. I'm proud to say that our outreach to the public has generated over 5,000 written submissions, overwhelmingly supporting stronger enforcement. By way of comparison, I think the last time around there were nearly 100. And many of those, if not most of those submissions, come from outside the Beltway. They come from farmers, they come from frontline healthcare workers, they come from entrepreneurs who are affected on a daily basis by the antitrust laws and corporate concentration. Finally, we're aggressively enforcing against monopolization. Unfortunately, there had not been a major DOJ monopolization suit for 20 years before the previous administration initiated the suit against Google, even as competition languished. Senator Sherman warned, and Senator Klobuchar foreshadowed this in her opening remarks, that monopoly power is a kingly prerogative inconsistent with our form of government. Today, that power harms small businesses, the free flow of news and information, and the vitality of our economy. The Antitrust Division is fighting back. First, we are challenging anti-competitive practices in court, as in our Google case and our briefs filed in the Facebook and Apple cases. And we are looking broadly at harms to the competitive process, including privacy and innovation. Second, we are working with Congress and the courts to faithfully realize Congress's original intent. Both the American Innovation and Choice Online Act and the Open Markets Act awaiting floor vote in full Senate are important to these goals. Our enforcement is efficient, effective, and saves taxpayers billions of dollars a year. For every dollar Congress invests in antitrust enforcement, we deliver returns to the American public that would be at a multiple that would be the envy of Wall Street. While I'm proud of the work we are doing, we lack the resources to fully address these challenges, and that is why we strongly support the Merger Fee Modernization Act. When I started at the division, after being confirmed, we had over 350 fewer people than we had in 1979. All the while, the economy has grown and antitrust cases have become more complex. In a moment, I'd also like to just, if you indulge me for one moment, I would like to acknowledge that today is my mother's 80th birthday. She's in the hospital recovering from hip surgery, but she's sitting alongside my dad. They're both inspiration to me, and I love them both very much, and I hope to make them proud. I thank this committee for its partnership and support, and I look forward to working together to help protect competition and to keep the American dream alive. Thank you.
Well, thank you so much, Mr. Cantor. We say hello and to your mom and dad, wish her goodwill in her recovery. And I just can't think of anything better way to spend your birthday than watching this subcommittee. Right. Can you, Senator? I mean, it's like a party. That's what I would be doing. Yeah.
It's exactly, I'm sure, what they imagined.
All right, very good. And next up, Chair Khan, thank you for being with us.
Chair Klobuchar, Ranking Member Lee, Chair Durbin, Ranking Member Grassley, and distinguished members of the subcommittee, thank you for inviting me to testify today. It's an honor to be here with you, and a particular honor to be here alongside Assistant Attorney General Cantor. The partnership between our agencies today could not be stronger. As is traditional, this oral testimony reflects my own views and not necessarily the views of the Commission or any other commissioner. Vigorous antitrust enforcement is critical to the growth and dynamism of our economy, as well as to our shared prosperity and economic liberty. Recent decades have vividly illustrated how Americans lose out when markets become more consolidated and less competitive. Prices rise, wages fall, and our markets become more fragile and less resilient. These effects have been on full display over the last year as supply shocks stemming from the pandemic and contaminated products have led to severe shortages and steep price hikes. Congress charged the FTC with enforcing the antitrust laws and promoting open markets and fair competition. We are pursuing this mission with renewed vigor, ensuring that we are faithfully discharging our statutory obligations. I am honored to serve alongside my fellow commissioners and our terrific staff whose dedication to protecting the public from unlawful business practices is second to none. While the Commission statement lays out a fuller account of our current efforts, I'd like to briefly share a few key pillars of our work. First, we are pursuing robust and vigorous law enforcement to protect the American public from unlawful mergers and illegal conduct. Over the last year, we have filed lawsuits blocking mergers across sectors, including in markets involving semiconductors, hospitals, the defense industrial base, and virtual reality. We've enjoyed significant success, with at least 6 mergers being abandoned due to an FTC lawsuit. We are committed to protecting Americans wherever we see harm and unlawful conduct, be it in mergers involving vertical players, nascent competitors, or serial acquisitions. And we are using our authorities to protect all Americans from unlawful deals and unfair methods of competition, be it patients and farmers or nurses and entrepreneurs. This has included scrutinizing practices like repair restrictions that can limit Americans' ability, including farmers, to fix their own equipment, and non-compete clauses that could lock workers in place. Second, we are canvassing all of the legal authorities that Congress granted us in order to ensure that we are faithfully discharging our statutory obligations. I take seriously both the text of our statutes and the controlling law and precedent, and I believe that upholding an approach to antitrust that is fully faithful to the legal authorities that Congress gave us is critical for promoting the rule of law. We are pursuing law enforcement with an eye to deterrence and targeting root causes of competitive harm so as to harness our resources most effectively. Third, we are undertaking our work with rigor and with an eye to tackling problems at their incipiency, limiting harms, and saving resources over the long term. We are making greater use of technologists, computer scientists, and a broad range of experts to deepen our understanding of emerging and next-generation technologies. In the vein of this forward-looking approach, the FTC recently challenged Meta, formerly known as Facebook's, proposed acquisition of virtual reality studio Within Unlimited, which the complaint alleges would undermine competition and innovation in the emerging virtual reality sector. Fourth, we have updated how the FTC interfaces with the public to solicit greater input and prioritize broad engagement. We now hold monthly open commission meetings where anyone can come raise concerns directly with us, and we recently convened a series of listening sessions with the DOJ to hear directly from market participants about their experiences with mergers. This public input is directly informing our work. For example, we received hundreds of public comments relating to business practices undertaken by pharmacy benefit managers, and subsequently we have launched a market study to understand how these PBMs are affecting drug prices and independent pharmacies. Finally, to maximize the impact of our enforcement efforts, the FTC is expanding and deepening its collaborations both domestically and abroad. We recognize the benefits of a whole-of-government approach to competition and are increasing our collaboration with other federal agencies, the states, and international enforcers. We benefit from the other agencies' expertise and recognize that these collaborations can also help equip our partners to diagnose and address competition problems more directly, which is urgently needed. Thank you so much again for the opportunity to appear before you today, and I look forward to the discussion.
Thank you very much. We have a number of senators here, so I'll get started. As leaders of our antitrust agencies, I want to know your views on how market consolidation, market power are affecting competition. What do you see the biggest challenges right now in taking this on? I'll start with you, Mr. Cantor.
Thank you, Senator. So without a doubt, as economy becomes more concentrated, there's less competition, and less competition results in risks to the American public. Those risks include higher prices, lower wages, and less innovation. And it certainly can affect the marketplace of ideas and the free flow of information, which is vital to the democratic process and the public discourse. In terms of the greatest challenge, there are a number of them. I think the most important is that we lack the resources. You mentioned Scotch tape and Band-Aids. We certainly need more Band-Aids and more Scotch tape, but I think we'd like a little crazy glue if you can supply it. We need more resources. We have 352 fewer people today than we had when, in 1979. I think with those additional resources, we can bring more cases to conclusions, and bringing more cases to conclusions could help start creating precedent that will allow the law to evolve and keep pace with a modern economy.
And as you said, you bring money in, is that correct, to the Justice Department?
We are a net contributor in so many different respects, Senator, including from our HSR fees, but also in terms of penalties and other mechanisms. So we are, for example, yes, and so
Okay.
yeah,
Okay.
good.
Chair Khan, what's your view of the status of things in general with competition?
I think we've seen from a significant amount of empirical studies as well as our own lived experience that declining competition in sectors has caused major problems for the American people. Higher prices, lower wages, lower rates of new business formation, stagnant rates of innovation, as well as crippling resiliency and more fragile markets. This is something that we take very seriously. We, of course, in addition to our competition mandate, have a mandate to enforce consumer protection laws, and we also see how increasing dominance and a lack of competition also enables consumer protection violations. In terms of the challenges, I mean, I would echo the AAG in terms of noting that antitrust enforcement resources has not kept up with the size of the economy. The number of people at the Federal Trade Commission today is around 2/3 of what it was in the early 1980s, around 500 people fewer, and that causes significant strain. It causes enormously difficult decisions for us about what types of unlawful deals we are challenging and are not challenging. I think especially when we had years like last year where deal volume was just phenomenally off the charts, it prompted extremely difficult choices for us and unfortunately made us realize that with the resources we have, we're going to do the best we can and fight to protect people the best we can, but fully delivering on the mandate that Congress has given us is extremely difficult.
I'm well aware from this from just my work on antitrust in this building, where the four big companies fighting the bill that Mr. Cantor referred to on self-preferencing and the like have something like 2,700, that's a minimum, lawyers and lobbyists, and we have two lawyers in our council. Here they are. They're very good. And so I know that feeling, and I think that this is an outrageous situation if we want to move forward at all.
And in our federal court Facebook litigation, we're outgunned at least 1 to 10 is what we calculated.
Exactly. Mr. Cantor, you were sworn in at a time when the Antitrust Division had more pending grand jury investigations. That was in 2021 than at any time in history. The division also indicted 20 criminal cases since last November, more than any time since the 80s. Would you share with us your approach to criminal antitrust enforcement very quickly?
Yes, I think there are three primary benefits, at least three, to criminal antitrust enforcement. First, practices such as price fixing and market allocation raise prices to consumers and deprive people of their hardworking money. Competition to fix wages can deprive Americans the opportunity to earn a better salary. And finally, collusion, particularly with respect to the procurement, deprives taxpayers of dollars, wastes taxpayer dollars, and leads to fraud and abuse. And so this area of criminal antitrust enforcement is absolutely critical to the work we do.
Thank you. And Ms. Khan, in January 2022, that would be this year, Martin Shkreli was found liable for antitrust violations brought by the FTC and a group of 7 state enforcers for interfering with the entry of a generic drug. We have strong feelings about generics here and the importance of competition. The court banned him for life from participating in the pharmaceutical industry, found him liable for $64.6 million in disgorgement. Do you believe this decision to hold him personally accountable sends a message to other executives about obeying the antitrust laws?
Absolutely, Senator. I think we've seen time and time again that when you just have fines as a remedy, certain firms can treat that as a cost of just doing business. And so making sure that we're holding executives, including top-level executives, accountable where appropriate can be critical.
Okay, very good. My last question, I'm concerned that Congress has held dozens of hearings on this issue related to your agencies, but hasn't followed up with legislative reforms to address the gaps in antitrust law, new market challenges posed by dominant digital companies. I've talked often in recent months about putting the mirror on ourselves instead of just complaining about everyone else. Do you agree that as our economy changes and new threats to competition emerge, is it helpful for you if Congress gave you new tools in order to enforce the competition laws? Funding, yes, but also new tools.
The answer is absolutely yes. As you're aware, Senator, the Department of Justice provided a full-throated letter in support of your ICOA legislation, along with Senator Grassley, and we remain enthusiastic about the prospect of Congress exercising its authority to give us additional tools.
Thank you. I'll leave because I'm over my time. I will note, Senator Lee, that we have a famous person in our midst, Representative Buck, the ranking member on our sister committee or brother committee over in the House, is with us, sitting somewhere in the back, I hear. There he is. We thank him for his courage and his really good work in this area, and we'd love to deliver a bipartisan set of legislation that we pass. Senator Lee.
He is indeed famous, and I'm glad to have him here. He's so famous that he's infamous, but he told me that that's not really the term that he likes to use. So,
Senator, I just want you to know I caught that reference to the Three Amigos.
Thank you. I'm so glad you got that. Extra points for you, Mr. Cantor. Chairwoman Khan, let's start with you. I'm hoping you can explain something to me. In the FTC's monopolization case against Facebook for its acquisition of Instagram and WhatsApp, the FTC relies on a personal social networking market definition. That's where they're going with that definition. And the FTC explains in its complaint that, quote, other types of internet-based services available in the United States that facilitate the sharing or consumption of content are not adequate substitutes for personal social networking services. In other words, seems to be saying, even though other services have incidental overlapping with Facebook, that doesn't mean that they're in the same market. And yet, in the FTC's complaint to stop Meta's proposed acquisition of Within, and remember, of course, Meta is just, the new name for the mothership at Facebook, that complaint relies in part on what they refer to as a, quote, VR fitness apps market definition. And the complaint states, quote, the broader market includes both VR dedicated fitness apps and incidental fitness apps, close quote. So here, the FTC seems to be saying that products with incidental overlapping uses are, in fact, competitors. Now, are these two market definition theories compatible? Because it seems to me that they are quite wildly inconsistent and indeed mutually exclusive. And I'm worried that the FTC putting forth these contradictory legal theories within a very short period of time, and these suits were filed within a year or two of each other, is something that could weaken FTC's ability to fight against big tech, and that concerns me.
Thanks for the question, Senator. As you know, our challenge of Meta's acquisition of Within is currently pending in our administrative proceeding, so I don't want to say anything that could risk prejudging that. I'll just say generally on market definition, these are very fact-specific inquiries, and I think our staff on both sides did a rigorous job in putting these forward.
Okay. Are you disagreeing with my characterization? I understand here the market definition is everything. Market definition matters. And the market definition might be differently assessed in one industry than in another. And it's hard for me to look at this and conclude that these are anything other than the same market forces at play. Do you disagree with my assertion that they are wildly inconsistent market definitions?
Again, Senator, I really would hate to prejudge anything while this.
I'm not asking you to prejudge it. You are the plaintiff in these cases. You're the enforcement agency. These are your allegations. I'm not asking you to prejudge. I'm asking you to describe your own agency's differing use of wildly inconsistent standards.
Once the commission votes to file a Part 3 action, as we did in Meta Within, there's a wall that goes up between the commission and the staff. So it's the complaint counsel, the staff, that are the plaintiff, no longer the commission.
Okay.
And I'm happy to check in with our staff and see what we might be able to share with you on a non-public basis. But again, we're very mindful of that wall and take care not to.
I understand that. I understand the distinction you're talking about. But again, we're not talking about prejudging here. I'm not asking you to prejudge the outcome of the case. I'm simply saying that the allegations raised in your complaint filed by your agency take two different approaches in essentially the same, in the exact same industry. It's hard for me to grasp that, but I understand you're not going to answer it, and that's frustrating and disappointing to me. Mr. Cantor, let's go to you. Imagine a court ruling, might not be too difficult, but a court ruling holding that a social media company with market power may be deemed a common carrier, and therefore could, consistent with the Constitution, be prohibited from engaging in censorship. Would that, or in what way would such a court ruling affect your assessment of whether such a firm is a monopolist?
Thank you, Senator. I would certainly want to make clear that it would be important to assess the specific facts and circumstances before reaching any conclusions, but to extend a court concludes that a firm is a common carrier, then that's certainly an indication of monopoly power, and the antitrust laws should apply accordingly.
Okay, so it may be an indication of that. You're not necessarily saying it would be conclusive, but it might be an indication of that.
Well, if it's a common carrier,
it's
likely to be pretty close to conclusive.
Right. In fact, it would be very difficult to get around that once you reach that conclusion that it's a common carrier, wouldn't it?
Well, I again want to reserve judgment on any specific set of facts, but as a general matter, yes.
What sort of thing could get one out of that conclusion once you had reached the conclusion as to common carrier status?
Sorry, Senator, I'm not sure I'm following the question.
If it's not conclusive, what would make it non-conclusive?
It really depends on the facts. One of the things I've learned in my practice, as I'm sure you appreciate from yours, is that every fact pattern presents differently, and you often see things that you don't expect or don't anticipate. And I think one of the most important things we do in our job is to make sure that we are assessing each set of facts before us. So I'm happy to answer generally, as I did, and directionally, but I do want to be very careful not to exclude a wide range of possibilities, some of which I might not be able to anticipate.
Understood. Looks like I'm out of time for this round. Thanks.
All right. Oh, very good, Senator Lee. Thank you. Next up, Senator Blumenthal, then Senator Grassley, and then Senator Whitehouse.
Thanks, Madam Chair, and thank you for having this very important hearing. Thank you both for being here and for your very good work. I don't think it'll be a newsflash to anyone in this room that Americans are beyond furious about cancellations and delays by airlines, and they're beginning to understand that the reason why airlines mistreat them and why they are mismanaged is because of consolidation. That consolidation represents one of the massive failures in antitrust enforcement, and the airlines' practices that have resulted are a preeminent example of corporate mismanagement. We don't have pilots or flight attendants, despite American taxpayers providing the airlines tens of billions of dollars. And Americans are absolutely enraged. In any competitive marketplace, if you paid for the product, like an airline ticket, you would actually have a seat. In a competitive marketplace, it would not be canceled at the very last moment. Or if you asked for your money back, you would get it, at least with proper enforcement, not be given a temporary flight credit. So I want to applaud, first of all, the Department of Justice decision in September to block American Airlines and JetBlue's attempts to combine their operations in several markets. And I want to ask you, Mr. Cantor, would you agree with me that both the Antitrust Division and the FAA has a role here too, should be very skeptical, exceedingly skeptical of any mergers or agreements that will lead to more consolidation in air travel?
Thank you, Senator. A week from today, we will begin our opening arguments in our case in Boston challenging the Northeast Alliance involving American Airlines and JetBlue. And we remain committed to fighting airline concentration when it breaks the law. As you indicated, Americans are furious, and competition can yield a wide range of benefits to air travelers, including better service,
I'm hoping
lower
you're
prices.
giving me a yes.
I think so.
Okay, thank you. Because I really think this is a matter of credibility for antitrust enforcement, and I hope that you will join me in that view.
Yes.
Chair Khan, just last week, our full committee heard testimony from Peter Zatko, whistleblower, also known as Mud. He raised a number of issues, including the misuse of private data, insider threats, and security vulnerabilities, deeply and gravely concerning. But one point that he made, which I think ought to be of direct interest to you, he said that Twitter is misleading, even potentially deceiving, the FTC, and that the FTC may have relied on those misrepresentations in failing to enforce the consent order against Twitter. I've asked for an investigation by the FTC. Are you investigating?
Senator, thanks for the question, and we were extremely disturbed by the allegations that we heard, and we take this extremely seriously. We're happy to be in touch with you to share non-public information. I'll share as a general matter the 2011 consent order that Mr. Zatko was citing really represents somewhat of a legacy approach. We've learned a tremendous amount since then and have applied those lessons in our more recent consent orders, including, for example, by including bright line prohibitions and requirements. So our subsequent orders have expressed limits on the type of data that employees can access. So we're actively applying those lessons and looking at this closely.
What came across to me, and I hope to you, is that the FTC has failed to enforce this order, perhaps because of lack of staff, perhaps before you because of lack of will. But Mr. Zatko warned that Twitter and others in big tech are not deterred by one-time fines. Again, not a newsflash, right? He recommended that the FTC should pursue other remedies, I agree, when there are violations by big tech, because there ought to be limits on big tech's ability to monetize its users. Would you agree?
I couldn't agree more. I think there absolutely has been a problem with companies treating FTC orders as suggestions. We have a program underway to really toughen that up. One action that we are taking is naming individual executives when appropriate, and we find that they've actively participated in or directed the underlying conduct. And so that's something that we plan to continue building on. More generally, I would say, some of the past orders that we had left a lot to the company's discretion. As I mentioned, we're tightening that up. We're also changing how the types of restrictions that apply to the third-party assessors. But I think you're absolutely right that the bigger question here is whether we're comfortable with firms that have business models that incentivize the endless surveillance and hoovering up of information, personal information. Some of the initiatives that we have underway are addressing this more holistically, including the rulemaking proceeding that we started earlier this month, which I think will better position us to address these issues. I think, of course, in as much as Congress is considering legislative proposals that would also address some of this data collection and the incentive to surveil head on, I think that will be most effective.
One of the questions I asked Mr. Zatko was how high up in the organization the knowledge and complicity in these deceptions in Twitter went, and he said as high as the CEO, Parag Agrawal. Will you name him if you find that he bears responsibility?
Absolutely. If we have a basis for naming individuals because we find that they meet the legal standard for that, we won't hesitate to do it.
Thank you. Thanks, Madam Chair.
Very good. Thank you. Next up, Senator Grassley.
I've pressed the Justice Department to focus on competition in agriculture. I've pressed the division on various agriculture competition issues, including concerns about specific agriculture mergers, market consolidation, anti-competitive behavior. I've urged the Justice Department to coordinate with the Agriculture Department on antitrust issues and trends. More recently, I've sent letters requesting that the Antitrust Division look into cattle market concentration as well as the fertilizer industry. So my first question, Mr. Cantor, is just kind of asking for an update. I've recently heard from lamb and sheep producers in Iowa that packer concentration is eliminating any market for them. You know well my longstanding concern regarding cattle industry market concentration. In fact, we discussed this when you first talked to me. Could you give us an update on what the Antitrust Division is doing with respect to cattle industry inquiry and other segments of the meat industry?
Thank you, Senator. First, let me just acknowledge the leadership, heroic leadership that you've played in advocating for a competition to the benefit of farmers, growers, and ranchers, and we are listening. We brought, I think for the first time that we can find, the first packers and stockyards claim out of the Antitrust Division relating to competition, certainly in generations, if not ever. And we intend to use that tool, which is something that you've suggested, with greater frequency to protect farmers and ranchers. We are also ramping up our agriculture enforcement program, both with respect to mergers and consolidation as respect to conduct. While it'd be inappropriate for me to discuss specific investigations, I would like to, if you're inclined to reach out to your staff so that we can arrange a briefing and provide you with a more direct update with respect to the specific activities underway.
I think I'll do that. To both of you, I've focused a lot of my efforts on trying to ensure there's competition in prescription drugs and healthcare markets and pushing agencies to aggressively enforce antitrust laws against bad actors. I've raised concerns with both Justice and FTC about certain behavior in the healthcare and pharmaceutical industries that I heard could be anti-competitive. I've collaborated with Senator Klobuchar on a number of bills to go after abusive practices like the Stop Stalling Act and the Preserve Access to Affordable Generics and Biosimilar Act. Both bills have passed out of the Judiciary Committee. Senator Cantwell and I have a bill dealing with PBM conduct and transparency that was marked up in the Commerce Committee a few months ago. Could each of you give us an update on what the Antitrust Division and the Federal Trade Commission are doing to ensure that there is competition in the healthcare and drug markets? What are the most pervasive problems that you've seen?
Thanks, Senator, and thank you so much for your leadership in particular on this issue. I know you've long encouraged the FTC to vigorously investigate and scrutinize the practices of PBMs, and we really appreciate your leadership. So we're taking a holistic look at the entire prescription drug supply chain. Most recently, we moved forward with a market inquiry looking at the practices of these PBMs. We've heard a tremendous amount of concern about these middlemen and the perverse incentives that they can face, especially given the vertical integration that we've seen in this market, coupled with horizontal consolidation. We've heard enormous concern from independent pharmacies about DIR fees. We've heard concerns from patients, including those that rely on essential medicines like insulin, about how the practices of the PBMs could be depriving patients of access to this type of life-saving medicine. So we're looking at this very closely. We also recently put PBMs on notice about particular authorities that we have under the antitrust laws, but also under things like laws prohibiting commercial bribery, that certain practices that we've heard about, including rebating practices, could be susceptible to prosecution under that type of criminal bribery statute. So we're continuing to move forward with this work, and addressing high drug prices remains a top priority for the agency.
Mr. Cantor.
Thank you. In addition to many of the same efforts underway at the FTC, including vigorous scrutiny of mergers and other conduct, we have a vibrant criminal antitrust enforcement program, of which healthcare is a significant focus.
Just for a minute, I'd like to make a statement, Ms. Khan. We have another with Senator Cantwell that would direct the FTC to conduct a detailed study of the PBM industry and its impact on drug price competition. I'd been pushing the Federal Trade Commission for years to look into PBMs, so I'm pleased that finally the Federal Trade Commission has voted to conduct a 6B study on PBMs, but I want to make sure that this study will cover areas that I've identified in my bill as well, just in case we don't get the bill passed. So I just want to make sure that we can get this study done in a timely fashion.
Of course, and we'd be happy to have our staff connect with your team to make sure we're covering those issues.
Thank you very much.
Very good. Thank you, Senator Grassley. Next up, Senator Whitehouse.
Mr. Cantor, we have been looking for documents from the Antitrust Division close on 3 years now without much luck. As you may recall, although it preceded you, even Senator Graham, as chair, got so frustrated that he asked the Deputy Attorney General to come up and explain why we weren't getting these documents, and we got some conclusory correspondence from AAG Boyd at the time. When Attorney General Garland came in, we tried to continue forward, and I was asked to stand back on the grounds that the Inspector General was going to look into this quickly and we would have better luck afterwards. In fact, that proved not to be true. The Inspector General was not looking into it. There was an OPR versus IG jurisdictional spat, so nobody was looking into it. I gather that ultimately the IG won that spat, and now they are looking at it, but I still can't get documents. And I would love to know your view on how it is that providing documents to a congressional committee, particularly in the era of a Xerox machine, and providing the same documents to the Inspector General would interfere with the Inspector General's investigation.
Yeah. Thank you, Senator. First, let me acknowledge I appreciate your interest and seriousness with which you take this matter. Prior to this hearing, and I've checked with our Office of Legislative Affairs, and I understand that they're actively working on responses to your questions, and I will take it back to them immediately after this hearing. With
You agree
respect,
with me that there is no place in the Constitution where congressional oversight authority is bounded by an Inspector General declaring an investigation?
let me just say that as my duties as the head of the Antitrust Division, I focus on antitrust enforcement investigations that deal with fraud, abuse, waste, or the integrity or ethics of any component are handled at the Inspector General level, which is the watchdog.
But you guys are lawyers. This is the Department of Justice. You represent the entire United States government. You know a lot about the law. There is no, am I correct in saying that there is no place in the Constitution where our power as the legislative branch of government to investigate the executive branch of government is bounded by a figure in the executive branch of government, like an Inspector General, saying, no, I'm going to investigate that?
Yeah.
And indeed, is it not true that Inspector General investigations and congressional investigations have, in fact, gone forward concurrently?
Senator, I will defer that question to our Office of Legislative Affairs and the Inspector General. My day job, I'm focused on enforcing the antitrust laws. And
well, they're your documents. That's why I'm asking you these questions. They're documents under the control of the Department of Justice Antitrust Division.
Right, but it's extremely important that I respect the independence of our Office of Inspector General, and it would be proper me to comment on any work being undertaken by the OIG.
I am certainly not asking you to comment on any work being undertaken by them. What is happening is that I am being told that I can't get access to documents that you hold because the Inspector General might also be looking at them. We have copy machines.
Yeah,
You
Senator,
can send a document to the Inspector General and you can send a document to us. It doesn't make any sense that I'm not allowed to receive documents because you're giving the same documents to the Inspector General, does it?
Senator, I certainly understand those concerns, and I don't disagree with the logic of what you're saying. Again, this is outside the scope of my duties, but what I will do, because it matters and affects the integrity of the Department of Justice and the Antitrust Division, is following this hearing, I will follow up again with our Office of Legislative Affairs and express the importance of
Well,
a
let me ask you a
timely
couple of
response.
general questions.
Okay.
When you decide to open an investigation of possibly anti-competitive conduct, is there a process that the division ordinarily follows?
So Investigations can originate in a lot of different ways, so it really depends. For example, a lot of our investigations are mergers, which are initiated by filing. Some are from tips, some are from FBI tips, some are from,
So
most of them are.
specifically, what role does a political appointee in the investigative process hold? Can political appointees play a role in the decision to open an investigation?
Under my authority, at the Antitrust Division, most often I've delegated the authority to open investigations to career employees. For example, in the civil area, the Director of Civil
Is
Enforcement.
that policy?
It is my policy.
Okay.
But it is not exclusive. So, as I indicated, an investigation can originate from anyone if the facts support an inquiry based on the law, and then we will feel free. We will initiate an investigation.
As a general, this will be my last question. As a general proposition, when different companies in the same industry organize together and combine and coordinate to lobby either a state government or Congress, that behavior is generally protected by the petition clause in the Noerr-Pennington Doctrine, correct?
As a general matter, the Noerr-Pennington Doctrine immunizes from antitrust liability the petitioning of a government.
And that's a decision you'd make right early if somebody asked for an investigation, right?
Typically, yes.
Thank you.
Very good. Thank you very much, Senator Whitehouse. Next up, Senator Blackburn, who was here right when we started.
Yes, I was. I was the first one here. Senator Cruz says he has a UC on the floor at 4:15, and if he could precede me, and then I'll go following him.
Okay, if one of our Senator Durbin comes back, we'll go in between, but that's great. Senator Cruz.
I appreciate Senator Blackburn's generosity, and thank you, Madam Chairwoman. Let me start by saying something I rarely say, and Senator Whitehouse is on his way out, but I agree emphatically and 100% with Senator Whitehouse. And
You want to limit that a little bit, or is that a general proposition?
I'm going to specify the context because that is not a frequent sentiment, but the Department of Justice has been abysmal in responding to this committee's inquiries. I've been in the Senate 10 years. The Department of Justice was abysmal under President Obama. It remained abysmal under President Trump. And if anything, it has gotten worse under President Biden. There's a culture at DOJ, an arrogance that believes the department is not subject to oversight from this Congress. And there is a culture of either ignoring letters or responding with dismissive boilerplate that, in my view, demonstrates a contempt not just for Congress, but for the American people. And I ask you to carry that message back to DOJ because I think DOJ is failing badly, and Senator Whitehouse deserves to have his letters answered, and so does every other senator here with candor and honesty.
Thank you, Senator. I commit to make sure that I relay that message exactly as you've delivered it with the seriousness that it deserves.
I appreciate that. Chairwoman Khan, I want to turn to the controversy around the use of the so-called zombie votes at the FTC. As you know, this process allows an outgoing FTC commissioner to, quote, vote on items before the commission even after that commissioner has left the commission. In my view, the practice is plainly illegal, and it jeopardizes the legality of any action of the commission taken pursuant to this illegal process. The practice is so absurd that earlier this year, the Senate Commerce Committee marked up a bill giving the FTC giving the FTC 13B authority. The committee, on a voice vote, incorporated Senator Moran's bill to prohibit zombie voting. So Republicans and Democrats came together and said, this is not an agency functioning properly if an absent commissioner is casting votes on matters he or she is no longer on the commission to cast votes on. And worse yet, we still know very little about this practice under your tenure. What we do know comes almost exclusively from public reporting because you have not been informing Congress about what is happening. And so I want to start with some basics. Outside of the 1984 policy guidance, a memo written by the FTC General Counsel's Office, which you and the FTC have cited in response to questions about former Commissioner Chopra's zombie votes, what other formal guidance in terms of memos, circulars, handbooks, etc., exist regarding the Commission's use of zombie votes?
Thanks for the question. That's the primary document. As you noted, this practice was initiated in the 1980s under Chair Miller. There was various guidance at that time, and so we followed course.
Prior to your tenure, has a zombie vote ever used to break a tie and be the decisive vote on the Commission?
I'd have to go back and see how it was done in the 80s.
But you can't cite any instance to this committee today?
Not specifically off the top of my head. I will say there was a lot of inquiry that we received about this, and we were able to send back information to the Senate. We'll make sure that you and your team have that information as well.
Will you provide unredacted copies of all the documents that have been prepared or that exist concerning zombie votes at the Commission?
Subject to check-in with our general counsel, we'll certainly provide you what we can.
Well, let me be clear, because I imagine you could come back and give all sorts of exceptions, like we have litigation over this. Let me remind you of what I just visited with Mr. Cantor about, which is the United States Senate is not the general public. Litigation exceptions don't exist for the United States Senate, and we have an oversight responsibility to know what's happening at the Commission.
Absolutely, and in as much as we're able to provide that type of non-public information in non-public settings, we will do so. I do want to clarify one thing about these votes. Any commissioner at any moment in time can cast a vote on something. Unless that vote receives a second, that vote expires within 30 days. So the idea that somehow...
But if they're not a commissioner anymore, it's qualitatively different than when a sitting commissioner casts a proxy vote. Let me dig into the details on your use of former Commissioner Chopra's zombie vote, specifically between October 12th, when Mr. Chopra was sworn in as the head of the CFPB, and May 16th, 2022, when Mr. Bedoya was sworn in as the fifth commissioner. How many former Commissioner Chopra's zombie votes did you use?
I'd have to confirm the number, but again, absent these votes being seconded, they were not.
So let me try again. How many votes did you use?
Again, I want to confirm, but it did not affect any enforcement action. I can confirm for you. There may have been a policy statement or so, but it was certainly under 5.
So you're saying there were no zombie votes on any enforcement actions?
As far as I'm aware, but again, we're happy to confirm that.
But you don't have the exact number. Did you anticipate this line of questioning?
So again, we're happy to confirm and get back to you. I would hate to misstate something publicly.
Well, let me ask one final question, which is, I'm an alumnus of the FTC. I think it is a remarkable institution that's done a lot of good. Under your tenure, morale at the agency has plummeted. I have here a letter from 16 alums of the FTC expressing deep concern about the politicization of the Commission and the resulting flight of senior staff from the FTC and the deeply diminished morale. And I'd ask unanimous consent that this letter be entered into the record.
Without objection.
And I would ask you, given the public reports of deep, deep dissatisfaction within the Commission, do you think the full Judiciary Committee, which has jurisdiction over the committee, needs to do an oversight hearing with all of the commissioners? We have not done one as long as the Democrats have had a majority on this committee.
I defer to the committee, but I'm always happy to appear before you all for any oversight.
Well, I look forward to it, if not this year, then early next year.
Thank you very much, Senator Cruz. Next up, Senator Booker.
I enjoyed my very brief moment as acting chair of this committee. I tried to exercise power.
You did such a nice job.
You know,
I want to thank you
I
for
just
that.
want to say Mike Lee took my without objection role in that line.
Sorry.
Yeah, you know, come on. Just you know, the partisanship on this committee is just awful. That you would undercut me like that. I would like to submit for the record that with that offense by Mike Lee, the morale on this committee has gone down considerably. But speaking of morale, Ms. Khan, can I just ask you to follow up a little bit about that? Because there are reports about staff morale going down with the FTC. Could you share your views maybe about what you've done to address it?
Yeah, I mean, I'll say up front, the staff of the FTC are enormously passionate about the agency's mission, and they fight every day against formidable obstacles to fight for the public. Of course, I take those survey results very seriously, and my team and I have been aggressively identifying what the source is and taking actions. We identified a series of ways in which we could have streamlined processes, provide better information. We've been doing so. We also had learned that uncertainty about what the future of work would be was one contributing factor, and we've provided more clarity on that too.
Great, and in fact, I think Senator Cruz generously talked about just how dedicated the agency is. There's a lot of civil servants there who've been there for decades, and I just want to know personally, what's it like to lead such a dedicated group of civil servants who've been there, despite who's president of the United States or who's the leading the agency at the time?
It's a tremendous honor. As you noted, we've had dedicated career staff there for decades who've been fighting very difficult fights on behalf of the American public, sometimes taking on fights that are extremely difficult against very well-heeled opponents and adversaries, and they bring enormous passion and commitment every day.
All right. Can I ask you a question about antitrust? And again, I make the deference that of the antitrust of the Democrats sitting up here on this committee, one of us has written a very good book about antitrust issues. One of us has not and got a bad grade at Yale on antitrust law, which is very hard to do, to get a bad grade at Yale for anything. So I do, though, want to go out on a limb here and ask an antitrust decision, knowing that the professor might take issue with it. But Antitrust Division just experienced really an enforcement setback, frankly, with the U.S. District Court rejecting its challenge of United Health Group's proposed acquisition of Change Healthcare. How does this outcome affect the aggressive stance that the Antitrust Division has taken in enforcing the antitrust laws and litigating cases?
Thank you, Senator. I will field that as the head of the Antitrust Division, and I congratulate you on your momentary chairmanship.
Thank you very much. It's a big moment for a guy with as little seniority as I have in the Senate.
Let me first take a step back and put some of our track record in context here. Since I was confirmed, we've had 8 criminal guilty pleas, 4 criminal trials with guilty verdicts, and 2 criminal trial losses, both of which resulted in 6 wins on motions to dismiss that establish favorable precedents that the department is likely to cite for decades to come. On the antitrust side, we've had 3 abandoned mergers in the face of challenge, including 2 relating to the shipping industry. We've had 1 trial loss, which came down yesterday. We're still reviewing the decision and determining the appropriate next step. Obviously, the court system is structured so that if there are appeals, they can be heard in due course. Let me also say that part of the job that we have before us is to litigate cases and to take risks when it's appropriate and necessary to defend the American public, particularly in areas such as healthcare. And we are not going to back down from bringing meritorious cases and seeing them to conclusions because too much is at stake for the American public, especially in areas such as healthcare. And so we will follow the facts and the law wherever they lead, and we will bring cases without fear or favor. And I am extraordinarily proud of my team at the Antitrust Division and the efforts that they have and the commitment they've demonstrated to defending the American public.
Well, as a former chairman of this committee, I would like to say to you, it's an issue we're very passionate about on a bipartisan way, and I appreciate that leadership. I'm going to squeak one more question in based upon the latitude of the current chairwoman. Ms. Khan, in your testimony, you shared a record of 3,644 transactions that were reported to the FTC and the DOJ in just fiscal year 2021. That's 87% more than the average number of transactions reported over the past 5 years. And we're just seeing historically high levels continue into this year. And I'm wondering if you can discuss the FTC's whole of government approach to protect the American people from what I suspect it could be the threat of unlawful consolidation.
It's absolutely true. Last year was a blockbuster year for M&A. We saw volume off the charts. We're working very closely with our government partners, particularly when they have particular expertise in an industry. So when we were able to sue to block the Lockheed Aerojet merger in the defense industry. We worked very closely with DoD. We've entered all sorts of new partnerships and new agreements with agencies across the board, including the National Labor Relations Board, to make sure that when there are issues affecting workers, that we're totally aligned. So this is an area where we continue to deepen our partnerships because, we're just one agency and there are a whole set of agencies with tools and statutory authorities that would also enable to them to check consolidation. And I think the president's deep commitment to this whole of government approach in particular has really lent new momentum and vigor to this effort. And we're incredibly proud to be part of that.
Thank you. I just want to thank you both for your commitment and service to this country. Thank you very much. And to the chairwoman, forgive me for being so rude, but next time you leave me in charge, please give me the hammer. Okay.
Promise you that.
Thank you.
Golden gavel.
All right.
Okay, with that, Senator Blackburn.
Thank you, Madam Chairman. Chair Khan, let me come to you. The Law and Economy Project. You spoke to them, the Law and Political Economy Project, and so my colleagues know this is an organization that has questioned capitalism and called for a revival of Marxist approaches to law and politics. And when you spoke at this event, you apparently said that government should play a larger role in, and I'm quoting you, shaping markets and economic outcomes, end quote. And you called the free market, and again I quote you, the product of metaphysical forces, end quote. So, do you think the FTC and you as chair should be shaping markets and economic outcomes? And what does that mean to you? And do you share the anti-capitalist views of the Law and Political Economy Project?
Thanks for the question, Senator. At the FTC, we're really committed to enforcing the antitrust laws and the laws prohibiting unfair methods of competition, in as much as the antitrust laws shape competition.
So you see that as a way to shape competition and to shape the economy in your perceived image by using antitrust laws?
We enforce the antitrust laws to promote competition.
Okay, do you agree with their Marxist approach to the economy?
I'm not familiar with the specific
So you went to
approach you're
speak to
mentioning.
them, but you didn't know what they were about. Let me move on and talk about mergers and acquisitions with you, because we've talked a good bit about this, and I've heard from some of the FTC's minority commissioners that they have said your actions are really harming small and mid-sized businesses. These have a chilling effect. And what they're referencing there is your push to go back and review a merger 10 years after that merger has taken place. So basically, if I'm a small company, what you're saying, if you want to merge, then you're giving me the ability, the FTC, am going to take the opportunity to come back and review your business for a period of 10 years. Is that an accurate assessment?
I would disagree with that assessment.
You would?
The FTC's monopolization lawsuit against Facebook did go after acquisitions that were made many, many years ago. That was noted, filed under my predecessor, but we're proud to be continuing it.
So you don't think small and mid-sized businesses, if they're looking to merge, then you're not saying, what you're saying is you want to come back and look at them for the next 10 years and judge them, assess them, have a review of them? Is that accurate?
So under the antitrust laws, we are permitted to review prior transactions. As a general matter, I'm committed to really focusing where we see the biggest harm, which oftentimes comes from the biggest companies. So we really focus our attention on the biggest mergers and where we see the most market power.
All right. You and I've had several conversations about privacy and the need for federal privacy legislation. Chairman Klobuchar and I have both been on this. And last month, the FTC initiated a rulemaking proceeding on commercial surveillance and data security. And the FTC is seeking comment on any number of issues, including algorithmic bias and discrimination, dark patterns, harms to kids, retaliation. That's a few of the things on your list. And this seems like a really broad inquiry that you are making without any really clear limits. So why are you doing this rulemaking now rather than waiting to see what legislation Congress might be able to pass and move forward? And how do you define commercial surveillance and mass surveillance, which are terms that you have used?
So I couldn't agree more that the best outcome here is for Congress to pass strong federal privacy law, and I firmly and fully hope that we'll see that happen. Candidly, given our jurisdiction, the types of privacy breaches, the types of security breaches that we see day to day compel us to think that we have a strong mandate to use all of our tools urgently, in as much as rulemaking and creating market-wide rules is a tool that Congress has given us. We, at this moment, are asking a set of questions to inform whether to continue with this. Of course, if at any point during this process, Congress, in fact, passes a strong federal privacy law, we'll, of course, reassess. We don't have the resources to just be able to afford doing these types of proceedings if they're not a value add, so we take that very seriously.
Okay, I appreciate that. I've got one other question on gig economy. I'm going to submit that to you for an answer. Thank you, Madam Chairman.
Thank you very much, Senator Blackburn. Next up, someone else who's written a book on antitrust in tech is Senator Hawley.
Thank you very much, Madam Chair, and thanks to the witnesses for being here. Let me start with you, Chairwoman Khan. A couple of months ago, I sent you a letter, and the other commissioners as well, regarding Amazon's acquisition of One Life Healthcare, which, of course, is a medical company that oversees a pretty extensive network of primary care providers. And I urge you and the other commissioners to scrutinize this transaction very, very closely. Part of my concern is, as I hope you appreciate, is that this is not an isolated case. Amazon has displayed a distinct interest in getting to the healthcare business on a very broad scale. Is this concerning to you? Let me just start there.
Without speaking about any specific transaction, both digital markets and healthcare are top concerns, and the type of expansion that we see, in particular by dominant platforms, is something we're looking at closely.
Good. In your written testimony, you listed a number of examples of mergers that threaten to raise healthcare costs and cut services. Let me just ask you in general, as far as you're aware, have consolidations in the healthcare industry redounded to the benefit of patients? Specifically, have they reduced costs to patients?
The economic literature that I've seen on that doesn't suggest that it has.
Why is that?
Well, the way our free market economy works is that it's really competition that leads to lower prices. And if you don't have competition, firms can instead be incentivized to raise prices. We've also seen quality degradation, where patients see worse health outcomes when you see this type of consolidation as well. So we're talking about price, but we're also talking about life and death.
Well, it doesn't sound to me like there's any good reason to think that Amazon's entry in this space would be good for consumers, but I look forward to your scrutiny of this. Let me just ask you, still on this topic, what concerns we should be looking at involving data privacy that might come about from either this acquisition or more broadly about mass consolidation, particularly when you have technology companies that are purchasing healthcare companies?
Yeah, I mean, again, speaking more generally, I think especially when you have firms that are integrated across multiple lines of business, there are a whole set of conflicts of interest that can emerge. Oftentimes, there aren't any limitations on how data being collected in one line of business is being used in other lines of business. And so we've heard concerns both from consumers, but also from market participants about just the deep conflicts and asymmetries that can create.
Very good. Let me ask you about the FTC's work and relationship with regard to big tech, and in particular, something that you and I have discussed in the past, and you alluded to this earlier today, is that the FTC's historic practice has been to levy what appear to be large fines on paper, but we know that the technology companies, Facebook, for example, the FTC leveled, I think, a $5 billion fine. Facebook stock went up when this happened. They don't regard it as particularly significant. They don't change their behavior. Tell us about the need to take on these companies when it comes to the remedies in a more meaningful way. What are you doing about that? What do you see the right approach being?
Yeah, I couldn't agree more. We're taking a more fulsome look at our remedial toolkit. In addition to naming individual executives where appropriate, we've also started requiring deletion of data. So we really want to make sure with a remedy that the lawbreaker is not benefiting from the fruits of its misconduct. And so in instances where data is unlawfully acquired, we're requiring that it be deleted as well as any algorithms. We have a whole set of really terrific technologists on board that are making sure that our remedies are actually being effective, especially in these types of instances.
Very good. Let me just give you a chance now to respond to some of your critics. Senator Blackburn raised an important point about this outside group that you spoke to, whose views they regard the market economy as a fundamental failure. They advocate Marxist policies. I assume these are not your views personally.
That's correct. This was a student group. We're really encouraged by the degree of student interest in antitrust enforcement, and so sometimes we do these events with the aim of encouraging folks to come to the FTC.
Tell us just about your own. I mean, my view is, as somebody who supports antitrust is integral to the operation of the market economy. I'm a capitalist unabashedly. I'm pro-capitalism. I'm pro-free market economy. I think our free market economy operates on robust antitrust enforcement, robust, free, and fair competition. Can you speak to that at all?
I couldn't agree more. Robust competition and fair competition has long been critical to the free enterprise, as well as core fundamental political liberties. I think the types of concentrations of power that we've seen in our economy, we now see how they both threaten our free market economy, but also core political liberties. And so I couldn't agree more with you on that.
Let me ask you just about one other point of criticism, and I just want to make sure that there's nothing to this. There have been reports that your office has conditioned merger approval, if only implicitly, on whether companies have adopted what I would characterize as leftist, liberal, environmental, social, and governance policies, ESG policies. In other words, the claim is that these companies are more likely to have their merger requests blocked if they aren't pushing things like, say, critical race theory in the workforce. Can you address that?
That's incorrect. Candidly, something that we do see sometimes is firms come to us and say, hey, we're proposing this merger. We know you'll probably identify it as unlawful, but we'll make all of these ESG commitments, and you should take those as a reason to bless the merger. I personally never find that compelling. I don't think those types of ESG commitments or anything in that vein can ever rescue an illegal deal. Okay,
and you would not in any way condition merger approval on the adoption of a particular set of ESG policies, just to be clear. That's not happening, wouldn't happen.
Absolutely not. I think, in fact, the merger laws prohibit us from doing that.
Very good. Thank you very much.
Thank you very much, Senator Hawley. And next up is, who was here first? Is it Senator Cotton? Thank you so much, Senator Cotton.
Ms. Khan, I want to return to a topic addressed by Senator Cruz and Senator Booker, and it's about the low morale at the FTC under your tenure. Senator Cruz cited a letter of former employees, but we do have data on this from survey from current employees. In response to Senator Booker, you implied that your employees may be concerned about what you called the future of work. That's not what this survey says. And again, this is from the Office of Personnel Management, President Biden's Office of Personnel Management. On one question, asked whether they have a high degree of confidence in my organization's senior leaders to maintain high standards of honesty and integrity, it went from 87% in 2020 to 53% in 2021. On another, in my organization, senior leaders generate high levels of motivation and commitment in the workforce. Again, it went from 80% in 2020 to 42% in 2021. On a third measure, I have a high level of respect for my organization's senior leaders, and it went from 83% in 2020 to 49% in 2021. Ms. Khan, why do your employees have so little faith and confidence in your leadership?
Thanks, Senator. As I said, I take these survey results extremely seriously. The survey was done quite early in my tenure, and since then we've been diligently identifying the source of some of these results and making sure we're taking aggressive steps to address them.
Do you think it reflects well that it was done early in your tenure? I mean, you took over there in June of last year?
That's correct.
The survey was conducted in November, 5 months later. So you think a 34% drop in the number of employees who have confidence in your honesty and integrity is something that reflects well on your leadership in just 5 months on the job?
Senator, as I said, I take these results very seriously, so does my senior team, and we're addressing it.
Do you think you'll improve this year?
We haven't yet heard when we'll get the results back from OPM, but of course we'll be looking at that closely.
Mr. Cantor, we may not agree on every bit of antitrust law, but I want to congratulate you on your performance in that same survey. It improved on almost every measure of senior leadership, so you must be doing something right at the Antitrust Division, so good for you. I'd like to talk now about the environmental, social, and governance movement, also known as ESG, which is really just an effort to weaponize corporations to reshape society in ways that voters would never endorse at the ballot box. Specifically, I want to talk about the ESG group known as Climate Action 100+, a group of investors and activists who have pledged to limit fossil fuel production both individually and collectively. The investment firm BlackRock is a prominent member of this group. Last month, 19 state attorneys general signed on to a letter to BlackRock CEO Larry Fink. The letter stated, and this is a quote, BlackRock's coordinated conduct with other financial institutions to impose net zero raises antitrust concerns. Group boycotts, restraining trade, or concerted refusals to deal, and again, this is another quote from the letter, clearly run afoul of Section 1 of the Sherman Act. Ms. Khan, do you agree that collusion to restrict supply is generally unlawful?
As a general matter, collusion is unlawful.
There's no antitrust exemption because you call something ESG, is there?
No, to the contrary, we've seen firms come to us and try to claim an ESG exemption, and we've had to explain to them clearly that there is no such thing.
So do you then share the state attorneys general's concerns that ESG coordination among financial institutions, including BlackRock, could run afoul of the Sherman Act or other antitrust laws?
I'd want to look at that issue in particular more closely before sharing an opinion on the legality, but certainly those types of cooperation or agreements, in as much as they can affect competition, are always relevant to us.
Mr. Cantor?
Yes, it's longstanding department policy not to comment on specific matters or specific companies, but generally speaking, directionally, Senator, I agree with the sentiment that collusion is anti-competitive, and I also agree with the underlying sentiment that when firms have substantial power and they use that power to achieve anti-competitive ends, that should be actionable under the antitrust laws.
Okay, thank you. I'm glad that you both agree that this raises concerns under the antitrust laws, as have many Wall Street lawyers and even progressive law professors, not groups of people that often agree with each other. I believe that enforcement, or at least investigation in these matters, needs to be pursued more vigorously. I think it may not be, because the whole point of the Biden administration's energy policy is to constrain supply of coal and oil and gas, and you see the dreadful consequences of that in what's happening in Europe and what will happen there this winter. So I hope that we get more vigorous enforcement, but if we don't, perhaps we'll get more vigorous oversight in January. Thank you all.
Thank you very much. Senator Tillis.
Thank you, Madam Chair. Ms. Khan, thank you for reaching out to me and having the conversation yesterday on the phone. I want to talk a little bit about big tech. I think some of these big tech platforms are using their market dominance to infringe on intellectual property rights of smaller businesses that really don't have the resources to fight back. So give me an idea of what steps, if any, your agency's taken to ensure that these dominant players are not taking advantage of their scale, not honoring the copyright, or I should say the intellectual property protections in the ecosystem. What, if anything, have you done, or what should you do?
Yeah, we take very seriously concerns, including from smaller market participants that have now become dependent on dominant intermediaries and gatekeepers, about the ways in which those gatekeepers can use that power. We've also heard about instances in which they're able to use the access that they have to the information of the smaller market participants to basically copy, surveil their products. This is something that we have alleged in our lawsuits in the past as well, and something that we continue to look at closely, especially when these types of tactics can be used to acquire or maintain monopoly power.
Mm-hmm. The FTC issued 6B orders in December 2020, I believe, to non-social media and video streaming companies. We haven't heard anything back. It's been about 21 months. So what have you learned?
Yeah, this was a study that was initiated in my predecessor. It was extremely broad, sweeping, covering a whole set of issues, very comprehensive. It is ongoing.
When would you expect a report?
We're pushing our team to get something to us as quickly as possible. As you know, these firms don't have an incentive to readily provide information to us, and so we're doing what we can to expedite this, and we'd be happy to see if we can provide you and your team a update, including any non-public information that might be relevant.
Do you see the report or the information that you gathered informing the FTC's recent privacy rulemaking?
Absolutely, and as much as there are
specific
key
examples?
issues of overlap. So, the 6B looked in particular at social media companies and particular practices that they deploy, including relating to advertising, including to kids. Those are all issues that are relevant to how we think about data privacy.
FTC voted 4-0 to block Illumina's acquisition of cancer startup test Grail, companies called Grail, but they lost in the court. 5 days later, the European Commission blocked the merger. Some have suspected coordination between the FTC and the European Commission. Can you tell me whether or not you or any of the FTC commissioners have coordinated or communicated with European Commission? The European Commission's taking up the merger as we speak. We're waiting on a decision from them. But does that interaction occur, or did it occur in this specific instance?
Yeah, so this is another one of these matters that's currently pending in our in-house administrative proceedings, so I need to be very careful about what I say. But as a general matter...
I don't want you to speak on the merits of the argument. I'm just more curious about the communication with your EU counterparts.
Yeah, so we, as a general matter, do have really strong relationships with our enforcement partners. Ultimately, we are all making independent assessments and determinations about whether a particular transaction is unlawful. Each of our jurisdictions is governed by different legal standards as well as different procedures. So while we do coordinate in order to promote efficiency and streamlining the investigative process, ultimately each of us is making independent determinations.
So in this particular transaction, is it accurate to say that there have been discussions between the EU and the FTC on this specific transaction, the Illumina transaction?
I believe our staff in the past have been in touch as the investigations were ongoing. I know there was a bit of a time lag in terms of when our team started looking at this. This is something that was voted out before I arrived, but my understanding is among the matters on which there had been enforcement cooperation and collaboration, this is one of those.
Well, we were just curious because I think it was 5 days later the EU blocked the merger. 5 days after you all lost in court, they blocked the merger. It looks very close. I'll leave it at that. And I'm out of time. I've got a couple of other questions I'll submit for the record.
Thank you very much, Senator Tillis. I think we're going to be joined by Senator Coons, but I'll ask a few questions here. I just want to clarify one thing and then maybe give you a break. Chair Khan, I'll go over to Mr. Cantor, who just looks like he has stuff to say. I don't know. On your question about sort of looking back at mergers and things like that, and you answered it because you were getting a lot of questions, but I just think it's really important to note. So a lot of us are concerned about some of the acquisitions that, say, Facebook made. I often wonder if, in the words of Mark Zuckerberg in an email, in fact, he once wrote, "I'd rather buy than compete." We'll never know what bells and whistles Instagram may have developed, but they bought them. And those cases, actually, that Facebook case, you said this, was actually brought under the Trump administration, under your predecessor. And does it look back at some of those mergers? Do you want to explain this? Because the allegation, I think, was made about you. But in fact, while I don't mind that they look back at something like that, because actually people within the Obama administration, like Gene Sperling, have said they wish they would have looked back at that, looked at those more carefully. Do you want to comment about that and what the case was that they brought back then, the Trump administration?
Yeah, absolutely. And I think this is just another indication of the strong bipartisan concern that we see on these issues. So that Facebook lawsuit was filed at the end of 2020. It alleged that Facebook's acquisitions of Instagram and WhatsApp were unlawful, an unlawful monopoly maintenance scheme. It also alleged that certain types of platform conduct had been unlawful. And in as much as Instagram and WhatsApp were acquisitions that were now made many, many years ago, that is something that would constitute looking back and addressing transactions that had already been consummated. That is something that is permitted under our statutes, and this was not the first time that the FTC has gone back and identified subsequently that a transaction that at the time that it was proposed had not been blocked, subsequently that the FTC determined it had the evidence that it had been an unlawful transaction.
Okay, and so that was brought under Chair Simon then, right? And you're continuing that work.
That's correct. Shortly after I joined the commission, we got an unfavorable opinion from the court, but we were given leave to amend the complaint, and we're thrilled that in January, the court denied Facebook's motion to dismiss, and we're now proceeding to trial.
Okay, thank you. I know you can't discuss everything about that, but I appreciate that answer. Both the Justice Department and the FTC have said that they regularly bring enforcement actions against vertical mergers, which is important given that so many of the recent large proposed mergers, whether in healthcare, tech, or video distribution, are not horizontal mergers. Do you want to talk about your agency's approach, maybe Mr. Cantor, to merger enforcement related to proposed transactions that are horizontal?
Sure. Thank you, Senator. It's important for us to make sure that our enforcement posture matches market realities. And as our economy has transformed, the markets are more three-dimensional than they've ever been. And so while sometimes vertical characterizations are appropriate, more often than not, we're finding that markets are multi-sided, platform-oriented, and competition presents itself differently in those markets. It can be competition for the platform. It can be competition on the platform. It can be disruptive technologies that reduce the competitive moat that protects a platform, or other types of technologies across a wide range of industries. And so when we think about merger enforcement policy, we start with the question of how does competition in this market present itself? What are the competitive threats that might exist to a firm with market power? And does the merger, in fact, undermine competition? If the answer is yes, then we will investigate and follow the facts and law wherever they lead.
Okay, thank you. And there is, I referenced the vertical integration. There does seem to be this trend toward vertical integration in healthcare and in video content. What's driving those trends? What are the long-term implications for competition and consumers?
The long-term implications are significant, and I think it's extremely important that we're vigilant in understanding the extent to which mergers might threaten competition with respect to building moats, foreclosing competitors, and depriving interoperability. And so we are going to remain vigilant in our pursuit of all illegal mergers, and I think there's rich case law, particularly around trends toward concentration, that we will take guidance from. And I should also note that working very collaboratively with our friends at the FTC and then with our respective staffs, including many of our career staff, we are in the process of revising our guidelines to make sure that we are even better reflecting the rich body of case law that addresses mergers, horizontal and non-horizontal alike.
Mm-hmm. I know in January of this year, the FTC and the Antitrust Division announced a joint public inquiry into modernizing the merger guidelines to better detect and prevent anti-competitive mergers. I understand you received over 5,000 public comments. That's lovely. Would you give us an update on each comment? No, I'm kidding. Would you give us an update on where that project stands and when we should expect new merger guidelines? And in your view, is there a place in the merger guidelines to consider how workers would be affected?
I would just...
Two separate questions.
Yes. As to the first question, I think reading those comments might be a filibuster strategy for inspired senator in the future. In any event, the project is underway. It's rigorous. It involves actually reading all of those comments, making sure that we absorb them, and then beyond that, making sure that we are consulting with the law first and foremost, and then speaking directly with our respective staffs. And so that process is pretty far along. We're working alongside very collaboratively with our friends at the FTC, and we hope to have an initial draft in the coming weeks or months.
Okay, thanks. I think we didn't run the clock, but I think I went 5-6 minutes. So next up, Senator Lee, and then Senator Coons has joined us. Thank you.
Thank you, Madam Chair. Chairwoman Khan, since your appointment as FTC chair, you've taken several steps that I think have diminished the role of the minority commissioners who serve on the FTC, such as giving only last-minute sort of drive-by notice of meetings and votes, and using omnibus resolutions to pre-approve broad swaths of future investigations. Even your written testimony that you submitted today was done on a partisan basis rather than seeking to reach consensus. I think this marks the first time since I've been in the Senate, and I've been involved in this subcommittee the entire time I've been here, that I've seen that. I don't recall seeing that ever before. And so if the FTC is going to, if you're going to run it more like a partisan entity, which I get it, but that is supposed to be one of the differentiating factors, is it not, between the Department of Justice and the FTC? The Congress that created the FTC is, of course, not the Congress in power today, but when it created this, with one of the things that it had in mind, we know because of the text and the structure and the language that they used, was that there would be a built-in bipartisan feature to it. You do differ in that respect from the Department of Justice, in that the officials who run the Department of Justice and the official, in this case Mr. Cantor, these people are appointed by the President after Senate confirmation, serve at the pleasure of the President. The FTC is different than that. But if you're going to run it as a partisan institution, how is that any different? Why should we even have two different entities?
So it's absolutely true that Congress designed the FTC as a multi-member body. Each of the commissioners brings unique expertise, and we benefit from that expertise. Sometimes that expertise means that there are legitimate policy disagreements that sometimes lead to 3-2 votes, 4-1 votes. We have had a whole set of unanimous votes. Testimony has, at least over the last decade, at several instances, not been passed unanimously, so that's just something that happens. I don't, second guess.
Okay, no, I get it. I get what you're saying. But it's charged statutorily as not just multi-member. And it's not just the term of years that you serve after you're confirmed, without being removable at the pleasure of the President. It's expressly bipartisan. Moreover, that still doesn't explain, and I understand, I appreciate it, as part of a deliberative body where we routinely disagree and where we have lots of dissents. I totally get that. That still doesn't address the most of the issues that I'm most concerned about here. The drive-by notification, last-minute notification, the sweeping omnibus resolutions approving broad swaths of investigations. I'm not asking or expecting that there be consensus here. I think there should. I do think it's troubling that there wasn't consensus in your written statement. I have never, ever, in my 12 years on the subcommittee, ever seen that happen. Maybe it's happened in the past, but not since I've been here. And it still doesn't explain what you're doing with the drive-by notification and things like that. That's deeply concerning to me. The language, as I recall, specifically, overtly says no more than 3 members can be of the same party. And so why not take the time to be more inclusive of participation in commission business by minority commissioners rather than marginalizing them?
We're absolutely inclusive on this issue of omnibuses. This is something that's been used on the consumer protection side of our house for many, many, many years. The change that we made was to bring the competition side of the house in conformity with the consumer protection. And this has really basically been a way to free up staff from bottlenecks, especially given that we now face additional urgency in bringing lawsuits while unlawful conduct is still ongoing. We face certain legal decisions that basically say that if the conduct has been halted, that we can no longer bring the enforcement action. And so pursuing streamlined investigations that are able to proceed swiftly has become even more important. And so the omnibus resolutions on the competition side, which again match what we've long done on the consumer protection side, have really been a way to empower our staff.
But staff aren't Senate confirmed. Commissioners are. Commissioners are Senate confirmed, and they're nominated specifically so that you have no more than 3 commissioners of the same party. Respectfully, the way you're operating it appears to me to be no different than if it were a partisan one. I mean, look at your statement today. I have not seen this in 12 years, a dozen years on the subcommittee. I've never seen an FTC chair submit something that wasn't a consensus statement from the commission.
I understand your broader point. If it will be helpful, we're happy to provide examples where that did in fact happen.
Okay, well, I would note for the record, they must not have been since I've been here. I see I'm out of time. I assume we'll have subsequent rounds. Thank you, Madam Chair.
Thank you very much, Senator Lee. I've gotten a very complex chart here, which I'm ready to share with you, Senator Lee, about times where there have been dissenting votes past FTC congressional testimony way back to 2015, 2012, 2011, 2010. Now, I don't know that it was oversight, this particular hearing that we're having, but I know that there has been for sure testimony where there has been disagreements on the statement, and I understand that because you're talking about our hearing and this sort of generic testimony. But I'll also note on something near and dear to my heart, when Republican Chair Joe Simons and the commission voted out the complaint against Meta, it did not have the support of these same dissenting commissioners. Is that true, Senator Khan? That's what my notes say.
That's right. The Facebook complaint filed under Chair Simons was also a 3-2 complaint.
So it was a 3-2 with the Democratic appointees?
Correct.
And
so
the Trump chair.
Commissioners Slaughter and Chopra joined Chair Simons in voting that complaint out, and Commissioners Phillips and Commissioner Wilson voted against.
It's neither surprising nor troubling to me that you would have dissenting views on proceeding with this or that investigation, this or that complaint. That's built into the equation. I get that. That's going to happen. Nor is it either surprising or troubling that in the past there might have been differing statements submitted on non-oversight hearings. What I'm saying is extremely unusual, and in my experience, in my 12 years here, unprecedented, is for an oversight hearing, the chairman to appear, the chairperson to appear with dissent from the chair's prepared remarks. That is troubling, and one of many things I find troubling in that regard.
Understand. I just want to point out that these same 2 commissioners also didn't agree with the Trump chair, and now they're dissenting on this. And it's the major case that I think is very much in the public eye is this tech case, is this Facebook case. And we have disagreements, of course, in Congress, or we would have passed some of our bills quite a while ago, Senator Lee. So, I just think part of this is really difficult to take this on. And I want to thank our witnesses for that, and really do appreciate your comments. We do try to make things as bipartisan as possible. And this has become a very tough area of taking this on. I know from my own personal experience. Next up, Senator Coons.
Thank you, Chair Klobuchar, Ranking Member Lee. It's great to be with you. Thank you, both Ms. Khan, Mr. Cantor. Mr. Cantor, if I might just, a quick opening question. During the previous administration, there were concerns that some decisions made by the Antitrust Division were improperly influenced by the White House in different directions. How have you worked to protect the career staff of the division from any political pressure or interference, and what steps have you taken to ensure enforcement decisions are being made in a properly independent way?
Thank you, Senator. We adhere strictly to White House context policy that's in place at the Department of Justice. And we have normal procedure that involves important investigations undertaken by staff and protect the integrity of our investigations. I can say unequivocally that they're free from political influence. We follow the facts and the law wherever they lead. And we make sure to have consistent procedure and policies across all of our investigations.
Thank you. That's encouraging. Ms. Khan, if I might, the FTC launched an investigation into a data broker, Kochava, I think I'm pronouncing that right, that the commission alleges sold very precise geolocation data that allowed the identification of sensitive personal location information for literally millions of people that can identify things like a visit to a health clinic or an addiction treatment center or your choice of a place of worship. And I'm concerned about how common this practice is, both of gathering reams of this data and then selling it. What other steps is the FTC taking or hoping to take to ensure that data brokers can't sell material about us that discloses easily this deeply personal information?
Thanks for the question. This was an incredibly important lawsuit for us. As you know, this is a practice that we see across the board, especially in kind of the murky area of data brokers. And there's very real harm that results to Americans, including, in some instances, physical violence, stalking, discrimination, stigma. So it's something we take very seriously. In addition to our law enforcement work, we currently have an ongoing rulemaking proceeding that is eliciting additional information about the extent to which this practice is occurring, its prevalence, its effects, and once the comment period closes, we will be determining whether it makes sense to proceed with rules that are addressing this market-wide rather than on a case-by-case basis.
So let's continue on that. I assume you're referencing the notice you issued, an advance notice of proposed rulemaking.
That's right.
On privacy that could touch a very broad range of areas: commercial surveillance, facial recognition, online advertising, mobile location data, cybersecurity breaches. These are very broad and are challenging given the resources, the power, and the scope of the FTC. Are you prioritizing your focus within those different areas at this point, or is that part of the purpose of the advanced?
That's exactly right. That's the purpose of the advance notice of proposed rulemaking, is to really on the front end be able to gather significant amount of public input, and from that be able to identify where do we see the most concerning, troubling practices, including those that we can say are unlawful, where do we see the most prevalent practices, and then we'll prioritize accordingly.
Last week, we heard from Mudge, Peter Zetko, a Twitter whistleblower who testified to the full committee, that despite the fact that Twitter was subject to an FTC consent decree, the company really took no substantive steps to actually substantively comply with that order. And in an exchange about penalties and cost of business and what motivates business to change their practices, he fairly directly said that the regulatory authorities in the United States do not in any way inspire fear on the part of Twitter leadership because of their scope and reach. I'm concerned, given that testimony, that the FTC lacks the authorities and the resources it needs compared to some other jurisdictions in comparably advanced economies to conduct real oversight and to effectively regulate some of the largest and most powerful companies on earth. What authorities and resources would be justified to bolster your enforcement capability in this context?
Well, some of the legislative proposals that we've seen specifically around data privacy and security could be useful. We have broad authority to go after unfair or deceptive practices. But for example, when you're bringing a deception lawsuit, the way to cure deception is through disclosure. And what we've seen for the most part is that disclosure in this day and age can, in many instances, be ineffective. We're thinking about how to ensure that we're fully using our unfairness authority, but I think there's more that could be done there. More generally, we are looking at our remedial toolkit in a more fulsome way to identify when we might need to name individuals or impose certain bans on business practices. So we're doing what we can, but additional authority, additional resources would be useful. One thing that I've prioritized since joining the commission is making sure that we have the technological expertise on board. We've been able to grow our ranks of technologists from 5 to 15, which is still way, way, way less than what we actually need in order to make sure that we're fully understanding how these markets are really working.
Well, I'll conclude by just commenting that a bill that the chair and I, Senator Klobuchar and I, and Senator Portman have worked on, the Platform Accountability and Transparency Act, would provide, I think, a balanced pathway for genuinely academic research into algorithms that drive platforms and how they work, would allow better insight into their impact on everything from mental health of America's teens to its impact on our political culture, to its impact on privacy and tracking of consumer activity, something that would help us have far better insight into the function and consequences of what's happening on platforms. It would have the NSF validating the research, but the FTC involved in some of the enforcement. I'm not asking you to comment on that. I'm just saying I think it's one piece of a positive path forward. Thank you for your testimony today. Thank you, Madam Chair.
Thank you. I'm going to turn over to Senator Lee for his last round here, but just speaking of technologists, so how do you define a technologist? Chair.
It's a great question. I mean, we've in particular brought on data security engineers, computer scientists, experts in AI and machine learning. This is actually an area where some of our foreign counterparts have made extraordinary strides. So the Competition Markets Authority in the UK is a real model here, and we've been working closely with them to understand how do we learn best practices from them.
So just to get some sense, I talked about the lawyers-lobbyist ratio because Senator Kuhn's question was good. So you said you have 5 to 15, depending how you define them, on or working with them.
We had 5 when I joined. We now have 15.
Okay. And how many, speaking of last week when we had Twitter come before us, which is not near the size of some of the other monopolists, how many does Twitter have?
So some of the estimates that I've seen range in the 4,000 area, including technologists plus engineers.
Yes, and I understand that's their business, but I'm just thinking about when it comes to some of the things that Senator Coons was talking about with algorithms and the like, and you're now talking about Google and Facebook and Amazon, for you to perform oversight and to enforce the laws, you are up against a lot. Is that correct?
Absolutely.
All right, thank you.
Mr. Cantor, recent press reports indicate that that airline ticket prices around this coming holiday season could reach a 5-year high. It's a concern to a lot of people, obviously. The Salt Lake City International Airport is one of the busiest in the country, and a very successful one. There are a lot of reasons for that. We're a great place for an airline to have a hub, and we're so grateful to have Delta have one of its major regional hubs there, as they also do in Minnesota. Maybe that's why we get along so well. We both love Delta Airlines. But Salt Lake City, like Minneapolis, is something of a gateway for a lot of destinations domestically and internationally. And a growing number of my constituents engage in some sort of telework and frequently need to travel out of state for work. But ticket prices have continued to become an issue, and ticket prices in and out of Salt Lake City have gone up substantially, I think, ahead of the curve relative to a lot of other places. So obviously I'm concerned for the well-being of my own constituents and that of the country about ticket prices. What's the Antitrust Division of the Department of Justice doing to ensure that my constituents and others of my colleagues throughout the country who are flying are the beneficiaries of lower prices, the lower prices and increases in quality that come from robust competition in the marketplace?
Senator, I share your concerns. At the Antitrust Division right now, we are looking very carefully at our approach to airline consolidation. We're opening a week from today in a significant trial relating to 2 of the largest airlines. We have numerous other matters under review. And I think we also want to make sure we learn from past experiences. And so, as you indicated in your remarks, a competition among airlines, among networks, lead to lower ticket prices, higher quality, greater transparency. All of those are extremely important dimensions of competition, and airlines are networks. And we need to understand the network nature of those businesses in order to make sure that we're enforcing the law effectively. And this is a very high priority for us.
Is this one of these industries where are there natural restrictions on entry? We do see a high degree of concentration in a small handful of firms. In other words, there are not a lot of new entrants in the industry in most years. We're seeing some of that now, I guess.
We've seen a lot of entry over the years, but a lot of that entry has been gobbled up through acquisitions. And so we are, actively making sure that if to the extent that new entrants emerge on the market, that they remain in a position where they can provide that disruptive impact and lead to more competition rather than increased concentration.
You have any idea how market concentration in the United States in the airline industry, how it compares to that of other countries?
So that's a great question. I think it depends on the country. A lot of countries have state-owned or subsidized airlines, and so they're not perfect analogs. But focusing on our free market economy, more airline competition yields many benefits to consumers. And we are eager, not just in terms of ticket prices, but also quality, mobility. You talked about telework. Having its critical infrastructure for our nation, and accessible, affordable air travel is something that we have to fight to preserve, and competition can yield lots of benefits.
Thank you. Chairwoman Khan, you mentioned the Commission's case against Illumina's acquisition of Grail in your written testimony, and you mentioned that as an example of the FTC's stepped-up enforcement efforts. But isn't it also something of an example of your agency's biggest weak spot? What I mean by this is that the in-house litigation process sets things up in an interesting way. And this actually ties back to my earlier question and my frustration with your earlier question, where you said you couldn't and wouldn't comment on the disparate pleading standards, the disparate market definitions that you used in the FTC's complaints, because you wouldn't want to prejudge it, which highlights a significant feature and a concern that I've got with the in-house litigation that occurs within the FTC, where the Commission essentially becomes the judge, the jury, the prosecutor, the enforcer, all at once. The Commission votes to file a complaint. The complaint is then heard by an administrative law judge, hired, employed, paid, and supervised by the Commission, listening to arguments presented by lawyers paid by the Commission. And then the ALJ's decision is appealed to the Commission, where the Commission, hearing arguments from lawyers representing the Commission, make those arguments to the Commission, and the Commission can reject, it can modify, it can even ignore the ALJ's fact findings in order to reach its own conclusions. At the end of that process, there is an opportunity for review in court by means of a petition for review. But this too can be illusory, as antitrust cases tend to be overwhelmingly fact-finding intensive, fact-finding driven. Under the substantial evidence standard used, which is something akin to the clear error standard, and given how fact-finding intensive these cases tend to be, it's not really much of a review at all. I mean, it's certainly nothing approaching de novo review, given how driven by these fact findings these decisions can be. So in what universe does this process comply with the Fifth Amendment's due process guarantee? Even setting aside for a minute the issues with unconstitutional delegation of authority or the major questions doctrine issues that might arise here. Just due process. Due process requires, among other things, that people know what the standard of the law is, and that there is a fixed rule of law standard to which they're accountable. How does this comply with due process?
So this is certainly not a unique feature of the FTC. There are a whole set of agencies that have this institutional design. I think there was tremendous wisdom that Congress displayed when crafting the FTC with its own set of particular institutional features, including this one. In as much as there's disagreement over that fact, that's something that's also playing out in the courts right now, as you know, and I'm sure we'll receive further clarity from the courts on this question in the years to come.
I certainly agree with you that Congress did design it. I also agree that there are reasons to do that. Those reasons are separate and distinct from due process. They are also, in my view, utterly incompatible with due process. And it highlights and further underscores my concern with the fact that you can't and won't answer the most basic questions I've asked about how you can raise inconsistent, mutually exclusive market definition standards in analogous cases because, as you put it, you wouldn't want to prejudge the case. This is not about prejudging any case. This is about pleadings that you're backing, pleadings that you're litigating.
Senator, I would love to engage with you on the substance.
Then do.
There is a long cautionary history here. Chair Dixon was frequently deemed to have prejudged matters that were before the commission in Part 3.
I'm not asking you to prejudge the outcome of the cases. I'm asking you to explain why those market definitions are so vastly different. If I am up in the night on this, if I am reading this wrong, and these are not actually mutually incompatible and indeed exclusive, I would love to know why.
I wish market definition were, not so central an issue such that being able to discuss it would not risk prejudging the substance and the merits of the case. Unfortunately,
it doesn't. You have filed these. These are your pleadings in your own proceedings. I'm not asking for a prejudgment. I'm asking for an explanation as to why you defined those markets so differently in two cases that are within the same industry.
One of the questions before the ALJ, and then if that matter gets appealed to the commission before the commission, will be whether the staff accurately and correctly pleaded that market. So, there really isn't much more for me to say on that without, in fact, risking this prejudgment issue. But again, happy to take it back to our team and see if there's anything else we can share. But we really need to be careful when that Part 3 wall does go up.
I understand that. And I strongly disagree with your conclusion, but I appreciate your candor. Thank you.
All right. Very good. Well, I want to thank both of our witnesses. This has been a very thorough hearing. We've had so many senators here to ask questions. I want to thank both of you for your really, really good work. This couldn't be more important right now, as things, I hope for much longer, appear to be stalled out on many fronts, including a number of bills Senator Lee and I have together. We're hoping we can get that done by the end of the year. The merger fee bill we referred to with Senator Grassley, the major bill that Senator Grassley and I have about preserving competition and rules at this time of market dominance by a few major tech companies, as well as a bill that Senator Lee and I have when it comes to Google marketing, something I have a feeling you know a little bit about, the two of you, as well as a major bill we have coming up this week on the news industry. So there's a lot of things happening, but I don't think it's fair for you to take the brunt of all criticism. Not that you are. Senator Lee was asking completely acceptable questions. But I think that, again, I say the mirror should be turned back on ourselves, and not just the two of us, but this entire Senate body in the House, because at some point we're going to have votes on these bills. The second thing is someone said to me the other day, and here I'm not really referring to the people in this room, but the greater cries out there that sometimes you do work where the critics are very loud and the supporters, while many, are very quiet. That kind of feels like the definition of my work right now, so I can relate to what both of you are doing. And that doesn't mean in any way when you are up against people, trillion-dollar companies that literally can run ads whenever they want or do whatever they want with their money, that you back down. I think it means the opposite. And I want to thank you for doing the work of the public. I think you've seen, while there's always going to be questions in an oversight hearing, and there should be, no matter who's in charge, that there is general support for moving forward to enforce antitrust laws. So I want to thank both of you. The record will remain open for 1 week until September 27, 2022. Do you want to add anything, my friend?
Thanks so much to both of you for being here and for answering our questions. Appreciate it.
All right. Thank you. The hearing's adjourned.
Thanks.